Hi, I'm David Gerard and this is Pivot to AI. Today, the big news just in yesterday is that Meta has won against Kadrey et al. This was the big author's case against Meta about them training their Llama LLM on authors' books, including on pirate copies. So, before I start, I'm not a lawyer and I'm especially not your lawyer, but I have spent 30 years in the trenches of the copyright wars and I do talk to actual lawyers, so hopefully I can offer some useful understanding. So, Kadrey versus Meta. Both sides brought motions for summary judgment on whether Meta's AI training was fair use. Summary means they both just wanted the judge to decide the question, and so Judge Vince Chabrier has done precisely that. Chabrier thinks, quote, "The companies, to avoid liability for copyright infringement, will generally need to pay copyright holders for the right to use their materials," unquote. But claiming fair use is not general. It is specific. Fair use under US law depends on the facts and circumstances in the particular case. There are 4 factors to consider. Chabrier found that firstly, Meta's use of the books was transformative, highly transformative. Chabrier says that's indisputable. They weren't just selling copies out of a truck or something, they were doing a complex thing. The second factor is the nature of the work, and books are just the sort of thing that copyright was made to protect. That one favours the authors. The third factor is how much of the book was copied. They copied 100%, but as Chabrier says, quote, "This factor favours Meta, even though it copied the plaintiff's books in their entirety. The amount that Meta copied was reasonable given its relationship to Meta's transformative purpose," unquote. And the fourth factor is effect on the market, the real concern for a lot of people. The authors basically failed to make much of a case here. Meta's Llama doesn't just spit out copies of the books. So the question is, quote, "whether these plaintiffs have presented enough evidence to raise a genuine dispute of material fact sufficient to give the question of market dilution to a jury." The answer is no. In their complaint, the plaintiffs asserted only 2 types of market harm: that users of Llama can reproduce text from their books, and that Meta's copying harmed the market for licensing copyrighted materials to companies for AI training, unquote. In summary, the authors lost against Meta because they just didn't present a strong enough case, and Chabrier seems disappointed they didn't. Chabrier even mentions Judge William Alsup's ruling in Anthropic from the day before. He disagrees with Alsup dismissing market effects as much as he does. He calls it an inapt analogy. But even then, Chabrier gives a much wider win to Meta than Alsup gives to Anthropic. So what about Meta's pirate copies? In the case against Anthropic, Andrea Bartz and the other authors got a big win, where Anthropic using pirate copies will go to trial for damages. That didn't happen in the Kadrey case because they didn't sufficiently convince Judge Chabrier that Meta seeded the pirate copies of books from LibGen. Quote, "The parties dispute whether and to what extent Meta uploaded via leeching or seeding the data it torrented," unquote. And Chabrier just was not convinced that the plaintiffs had proven their case on that. So, there's a lot of people really upset over this ruling, but we have expectations and we have reality. This ruling and the Anthropic ruling from a couple of days ago are the facts on the ground now. The parties to the cases asked for the decisions and they got them. And these rulings on fair use follow from a lot of rulings over the past year, and those follow in a straight line from Authors Guild versus Google, which ran from 2005 to 2013, where authors sued Google over scanning their books for Google Books, and it was ruled solidly a transformative use, and that was upheld on appeal. So it looks like training AI on books is likely fair use now. You might feel it shouldn't be, and you're allowed to be outraged. But firstly, tell it to the judge. And secondly, if you really want to change this, you're going to need new laws, because the meta ruling and the Anthropic ruling follow directly from many years of precedent on the legal meaning of fair use. Read the decisions and each of the steps the judges go through to weigh up the fair use factors. This is all standard procedure. Both of these decisions are district court decisions and they're appealable, so maybe the losers will appeal. Meanwhile, just yesterday, there's been a new class action case, Bird versus Microsoft, that is specifically about Microsoft training their in-house AI models on pirated copies. And I'll have to cover that one as it proceeds. If you want to comment on this YouTube video, please at least read the decision before you comment. It's linked in the show notes. And for the podcast listeners, just be thankful you don't have YouTube comments. Thanks for tuning in to Pivot to AI. If this episode was helpful to you in understanding this ruling, please tell at least one other person about today's episode. Please hit like and subscribe, leave a podcast review, and Pivot is funded by you, the viewers and listeners. If you can put $5 into the Patreon in the show notes, it's hugely helpful. Thank you all. See you tomorrow, and bye for now.